Sure. Here's a more polished version with the same tone. Hey everyone, and welcome to today's video. We've got a lot to cover. 2 idiots angering the wrong judge, 2 judges stepping down for some pretty solid reasons, and an update on our favorite Sardian, Eric Martin. We're starting things off at Connaught Municipal Court, where we've got a genius who's out on bond for driving without a license, but somehow still thinks it's a good idea to keep getting behind the wheel. Let's dive in. Would you like to adjust the tone further, or keep it in this casual, straight-to-the-point style?
Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom, driving against court orders, while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Of course. Here's a polished rewrite that keeps your tone and humor while tightening the flow. Can you see now why I actually enjoy watching this judge? He's fair, he's firm, and he runs his courtroom like a boss. In fact, we're sticking around in his courtroom for the next defendant. Now, here's where it gets interesting. This next hearing is taking place in front of a group of young kids who are apparently on a courthouse field trip, and they're about to get a real-life lesson in the true meaning of mess around and find out. Want it even sharper or toned down for a broader audience?
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say?
Excuse me, but what did you just say?
What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here. Sir, come. Get out of here.
Absolutely. Here's a cleaner and more structured rewrite while keeping the tone casual and engaging. He didn't take her case back up that day, but I don't think it really mattered. She was there to turn herself in on a bench warrant anyway. Now, on to our next case, which took place last week in Judge DeSanto's courtroom. Things get a bit wild in this one, as the defendant starts throwing out accusations of racism left and right, aimed at just about everyone. But Judge DeSanto wasn't having any of it. Would you like it with a more formal tone, or are you aiming to keep this casual and narrative-driven?
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Perkin Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Brady Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
Certainly. Here's a more polished and professional rewrite while keeping the sharp tone and humor intact. This is actually a rather unusual situation. Typically, when a lawyer is removed from a case, it's at the request of the defendant. We often see this in sovereign citizen trials, where the defendant fires their attorney for refusing to indulge their delusional legal theories, hoping the next lawyer will happily join them in their fantasy world of crayon-flavored legal doctrines. But in this case, it's different. The conflict arises from a disagreement in legal strategy between the defendant and his attorney. Ultimately, the defendant has the right to pursue whatever legal strategy he believes is best, no matter how misguided. That's likely why the attorney is the one requesting to be recused. He probably doesn't feel comfortable risking his legal license by attaching it to the defendant's frivolous motions. And understandably so, especially when he's being forced to compete with the defendant's second legal team, the ever-reliable firm of Pro C, Dick Flute, and Dumbass. Want this version toned down, made more formal, or kept in this sharp, sarcastic style?
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing. and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today, asking for this court.
For the videotape, hearing of bail and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on
recorded
transcript.
on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Sure. Here's a more polished and assertive rewrite of your sentence. I don't think it's wise for you to be defending yourself, especially when you don't even know the proper procedure for something as basic as requesting court transcripts. Would you like it to sound more formal, more aggressive, or more casual?
If I request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17, and you're requesting under 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at the city of Woodhaven public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional right.